You may have heard lately in the news that the next big thing is self-driving cars. A lot of the big companies are in on it. There's a Google-owned company called Waymo. Uber is big into it. The car manufacturers are all big into it, and there's a big fight over who's going to get a leg up with the technology. There's been a lawsuit relating to it recently that tells us something about non-compete agreements and trade secrets. What has happened is there was a star engineer called Anthony Lewandowski. He was at Waymo, but he left Waymo and went to Uber. Apparently, before he left, he downloaded 14,000 confidential files and took them with him. And so Waymo decided to sue Uber and claimed that Uber had stolen Waymo's trade secrets. Waymo asked for a temporary restraining order, asking a judge to shut down Uber's self-driving program completely and to keep Lewandowski from having anything to do with it. Well, there's been a ruling in that case. The judge has denied the TRO as far as shutting down Uber's program completely. But the judge did rule that there are apparently going to be some issues relating to what Mr. Lewandowski did. It's a little bit of an unusual case because Lewandowski was not actually sued. He's not a defendant in the case, but he was asked to provide information about what he did and what he took. And instead of providing that information, he fought it and said that he had the constitutional right to remain silent to protect himself from criminal incrimination. Basically, he pled the fifth. So it's an unusual procedural posture, but obviously the judge seems to think that something inappropriate took place. What has happened is now the judge has prohibited Mr. Lewandowski from being involved in that self-driving program at all. Essentially, the ruling is what we'd expect. The judge is very careful to protect trade secrets, careful to enforce non-compete agreements where they're appropriate, but also wants to make sure that companies can innovate, that companies can compete. The decision by the judge not to enforce the TRO and not to prevent Uber from having its self-driving program at all is pretty typical in that courts try to make sure that they're not shutting down businesses except to the extent absolutely necessary to protect someone's trade secrets. Now, Mr. Lewandowski's troubles don't appear to be over. The judge has referred his case to the Justice Department for possible prosecution, and employees need to be careful that they don't take trade secrets, that they don't do inappropriate things as they're on their way out the door, so to speak, because it appears that Mr. Lewandowski might have problems in those regards. One of the things that has come up undoubtedly is the issue of the Defend Trade Secrets Act of 2016. That's a new federal act. It relates to companies and how to protect their trade secrets and the remedies that they can pursue if they believe their trade secrets have been stolen. We have a previous video on that subject that you're welcome to go view if you'd like to. The gist of the law is that employers need to make sure that they plan to protect their trade secrets. Trade secrets are important, but they have to be protected, and employers have to take careful measures to make sure that they've done the things that they need to do in order to be able to enforce those trade secrets, and if necessary, go to court to protect their rights. You've got to have those trade secrets protected in ways that you can prove to a court if it becomes necessary. You need to use an attorney who's familiar with these trade secrets, non-competition laws, and similar laws. Here at Denton Peterson, we've brought and defended a number of these sorts of actions. We deal in non-compete contracts every day. We deal with trade secrets every day. We deal with the duty of loyalty that an employee owes to an employer all the time. If you have any questions regarding any of these issues, please don't hesitate to give us a call.